Okay, good morning, everybody. I think we'll get started here. It's, what is today? It's September 28th, 2017. The time right now is about 9:14. This is the second meeting of this working group, stakeholder meeting for review of Group 2 of the rules that we have agended. So what I always try to do is, at the start of this, obviously, is let everybody know that this is a recorded meeting. This recording absolutely goes on our website within the next week to 10 days, so everybody in the outside world can log on and listen to this. And definitely have interested persons out there that do that from time to time, and also the board has the ability to do that, to see what goes on in the stakeholder meetings when the rule is finally noticed and it gets to them at a formal rulemaking hearing. So with that, I would just encourage you all to attempt not to interrupt anybody, let people finish their thought, and then jump in at that point in time. Also, I always have everybody introduce themselves on the record, so the listening public out there knows who was in attendance at the meeting. So with that, I'll start. Bruce Zuloff, Director of the Auto Industry Division and Executive Secretary of the Colorado Motor Vehicle Dealer Board.
Chris Rouse, Colorado Department of Revenue, Auto Industry Division.
Criddell-Tapanen, Meeting Recorder.
Frank Agos, Auto Industry Division.
John Opeka, Auto Industry Division.
Corey Amen, Deputy Senior Director of the Enforcement Business Group.
Chris Hartman, Auto Industry Division.
Michael Dahmer-Muse from Fairfield and Woods on behalf of the Colorado Automobile Dealers Association.
Matthew Groves, Colorado Automobile Dealers.
And Tim Jackson, Colorado Auto Dealers Association.
I'm Jeff Seaman. I'm here on behalf of the Motorcycle Industry Council and the Alliance of Automobile Manufacturers.
Helen Hayden, Auto Industry Division.
Steve Perkins, Motor Vehicle Dealer Board, used.
Leland Beebe, Legal Assistant, Auto Industry Division.
Bradford Jones from the Colorado Attorney General's Office, General Counsel to the division and to the board.
Thank you all. So just jump into the agenda. We're going to, item number 2, the working group, the meeting scope today. So we have agended again 11 separate rules. We talked about this at the first meeting. We went through each of those. We've got quite a bit of input from everybody about, sort of where they're at or sort of their opinions, but everybody wanted to go back and regroup. We asked for written comments from people if they want to do that. I think we did receive 1 or 2 written comments, one for sure. Was that from your colleague, Jeff?
Yes.
Okay.
On behalf of the Motorcycle Industry Council.
Correct. So that is included in what the blast email that went out last night. I apologize for the late email, but that happens in government. It's just the way it is. But so I know that you may not had a long time to look at this. What Leland Beebe has done is he's went in and looked at these, and he has given some legal analysis of the statutory scope of things. So when we get to that, Leland can weigh in on some of these things. My hope today would be this. I think that based on our conversations last time, the first 9 rules as they are on your agenda, the first 8 rules, there is no need in the division's opinion to change those, or the ones that need change, it's very, very minor. And I think sort of everybody was somewhat in agreement with that. Certainly you don't have to have that opinion today as we go through those. Obviously, number 9 is the power sports regulation has to do with the ANSI standards, and Jeff will weigh in on that. They have made a proposal for that. And I think the big ticket items, again, are the last 2, number 10 and 11, is the off-premise permits, because that's a very dynamic rule and a very dynamic issue that we will have to spend quite a bit of time discussing. My goal here today is get through the first 8 with somewhat speed, not locking anything in, and make the little changes that I think we're going to be at consensus on or near consensus. Talk about number 9 and see where we're at on those, and then spend the bulk of the time after we get through the first 8 or 9 on number 10 and 11 and see where we need to go from there. My goal was at the end of the day to not have another stakeholder meeting on group 2, and we would go back, the division go back and regroup and just notice the rule, draft the rules and notice the rule, but there may be a need for a 3rd meeting, especially around the power sports issue, because I don't know that we are going to be able to get to somewhat of a consensus today on that. So if that's the case, we would take that up at October 17th at 1:30. That would be after the normal board meeting, and we would try to only take up number 10 and 11. So my goal is to try to get through all the first 9. So with that, are there any questions from anybody about the scope of today's meeting, or any comments that we need to get on the record before we move through these? All right, so hearing none, let's just... Okay, I'm sorry,
Just raise one. I don't see an email from last night, so is it possible to have that?
You didn't get it.
I didn't get it.
Went to your associate.
Okay, I'll ask her to send it to me.
Sorry.
Thank you.
On the same vein, Leland and I had left the office before this came out. Do you have extra hard copy of that?
I do.
Thank you, sir.
So, Mike and Jeff, there's nothing earth-shattering in that. I think what Leland has done is some good work on analyzing some of the statutory authorities and so on and so forth. So with that, let's just jump in to, on the first agenda item is 126104-3E, which is a current regulation. This is a delegation of the executive secretary inter default under specified circumstances. When we looked at this, when the division looked at this a month ago, and then when we talked about this at the first stakeholder meeting on this one, I think the division thought that this particular rule was not broken and probably did not need any kind of revision. If you look on what would be the second page of Leland's analysis, and I think he after he did the legal analysis, he said that there appears to be no revision needed. It fits the APA still, and so on and so forth. So with that, comments. Sorry, Mike, I'll get Michael and Jeff give you a chance to sort of read that analysis.
Bruce, one question I have on this is, what if a dealer alleges, I never got notice of the charge and I never got notice of the entry of default? It comes in 6 months later. Any due process concerns there if they allege that lack of notice?
I think it's a fair question. Here's what we do.
We covered that. You don't.
Yeah, I mean,
you do a very thorough job of trying really hard to get notice.
We try to do the best we can, but we actually had one this last week that we debated on where to send this. Just give you an example, is the last notice, the last known address was that they supplied to us by statute or regulation was a Florida address. Come back undeliverable, and this is kind of a nasty one where the division is very certain that this person has fled the country because of a criminal charge.
Right.
So what do we do on that kind of a situation where we really don't know? Your scenario is what happens if that person maybe is still in the state but just hasn't updated addresses and so on and so forth. So I think, I guess I would be looking for some kind of suggestion. How do you, if there's a need for a revision of the regulation, how do you do that?
Well, first of all, I think it's incumbent upon a licensee to keep their address with you current. Let you know where you can find me. If I hold a license, if I hold the privilege of holding a license with your department, it's incumbent upon me to keep that address current, first and foremost. And it's tough for me to imagine a scenario where somebody is justified in not keeping you current in where they are, and so you can't serve that notice on them. So, that cuts against the issue that I raised. But, a lot of times when I look at an issue like this, I want to understand, well, what if extraordinary circumstances prevent that person from getting that notice, that there is a charge pending against them, that there has been a default entered against them. This says that if they don't do something within 10 days of the entry of that default, they're out of luck. And I wouldn't know how to cure that unless you wanted to put it within 10 days of the person getting notice of it or something like that, putting that proviso in it. Now that opens the door then to say, 2 years down the road, somebody's had a default entered against them, coming back in later to challenge it, to say, hey, I never got notice of this. So that does have that. That's the other side of that coin.
May I respond? Mike, what I have found when I've researched default in Colorado is that it is one of those places that the courts abhor default. They do everything they can to avoid upholding default unless it's handled exactly according to the rule or statute that applies. But if people do everything, right to the letter of what the law says they must, then the defaults are upheld. And what it appears, at least at first blush from analysis, is that this is a pretty conventional looking rule based upon, a basic provision of the APA that was fashioned to go along with the civil rules, requirements, and other things that are in the state. It's a consistent, platform of action. And, you could always have somebody come in and take us to court and say, I got defective notice, I didn't get notice, whatever, and then we'd end up having to support the process. But, you probably know that, most notice that we do is a notice that is based entirely upon it being sent to the right place. We don't actually have an obligation in most cases to do actual notice, a direct notice to the person. So, and that, that's the way it is. If we
Yeah, that's laid out under 24.4.105.2A.
Okay, so this mirrors the statute.
Yeah.
Yeah.
Okay.
Yeah, and it says last known address, and that's how we've been proceeding. And then, in circumstances where there's good cause, they would have to show good cause, and that's in accordance with, or similar to Civil Procedure Rule 55 and then 121.
I know there's a time period under 55 where you're out of luck. Is it also 10 days?
Let's see, I'd have to review that because.
And I don't have the text
Generally.
with me, so I apologize. I was just looking for that.
I think one of the reasons when we talked about this at the division level, why we thought it wasn't broken, is because it's so seldom used. We do 3 or 4 defaults in the entire year. And most of those defaults are not that it went to the wrong address, you didn't notice it, people just don't want to participate in any kind of a defense of what happened. They're just out of the business and moved to a different state, and they may get notice, and they're just non-participatory on probably half of the defaults that we do. So 3 or 4 a year is probably the most we do.
There is not a specific time under Rule 55, but it has to do with good cause, because the longer it takes for somebody to come forward, the less good cause generally a judge may find, or the director. And I guess I shouldn't go into any much more detail than that at this point. So the 10 days is just a requirement that the board has set just because of the nature of the industry.
The Colorado Rule Civil Procedure 60B contemplates 6 months. If you're going to need to set aside a default judgment, you have 6 months to do that. So I'm not advocating that a 6-month standard apply here as well, but I just wanted to raise that as a potential due process issue on the notice piece.
Is your concern at a high enough level that you think that the regulation maybe needs to be tweaked?
Probably not.
Okay.
Just wanted to raise it for discussion.
Okay, duly noted, so, okay. Anything else on E? With that, although we're not locked into this, I think what we will do is we will consider that this stakeholder group has discussed this particular regulation, and we'll move this forward with no modifications. Certainly, there's probably another chance for input before we do that, but as of now, we won't come back to this one unless we get some kind of written comment that we need to reconsider, okay? So the next one is the same issue, exactly the same issue, the same regulation, but there is not one in the power sports side. So this would require us to enter rulemaking and draft a sister regulation, the same as the motor V regulation for the power sports side. 126504-1E1 is where we think the proposed regulation needs to sit. Any comment on that?
No comment. No objection.
Okay, then we'll move that one in the same manner forward. That brings us to 126105-1B. It's item number 3 there, motor vehicle regulation, delegation of authority to the executive secretary to perform ministerial acts. When we looked at this, the division looked at this. Let me find it. We did think that there were a couple of issues that needed some minor tweaking. We don't think it is necessarily broken, but we do think it can be strengthened in a couple of areas, in one area specifically, and that is the very last paragraph having to do with the executive secretary, the authority to conduct an informal fact-finding conference to make recommendations to the board for the granting or denying of an application for a motor vehicle salesperson license. We think that that's too restrictive, and the executive secretary should be allowed to do an informal fact-finding and make recommendations to the board, either granting or denying for all applications. And so that would be our proposed modification to this. And I don't think we, the division, have any other modifications that we are suggesting.
Yeah, we do.
We do?
Yeah. If we're opening the rule,
Well, we'd have to open it to make that change.
yeah, the statutory authority, the namesake, has actually changed. So it's changed by a digit And
So it should be 2B.
Yeah, it would now be 2B, so we would probably make that change in the name, quote, quote, of the rule. And then also, OLLS has, in the last 20 years, changed its, internal reference standards for something like a statute placed in reference. And we could comply with that easily. Just yet, that's a very minor thing. But if we're going to open it, they're going to notice it, so, why cause them some grief or us some grief with them?
So is the last thing you're saying substantive change to the words within the regulation?
Yeah, it means that you change the way the reference is made. I mean, they have changed their technical.
So tell me exactly what you're suggesting, because this is new to me. So tell me exactly what you're suggesting.
Yeah, we've actually done it historically, but it just changes. They don't do the CRS anymore, okay? If you're referring to a state statute internally now, you can just refer to it without the CRS. So that's how they do it.
So you're saying in paragraph 2,
Right.
126104.3F2 CRS, that reference just needs to be changed in some way.
Just made to be consistent with the OLLS standard.
Okay. Anything else?
No.
Comments?
Bruce, I have one question, and pardon my naivete, but the permissive language around what's written, I just have a question about that. So does that suggest an order or a subpoena or a motion might be written, might not be written?
Yes. So the real-life example of that is the board, through delegation of authority, has, I give you the best example of that, through delegation of authority has granted me the ability to actually deny a license for material misstatement. So what happens on that, Jeff, is mostly salesperson fills out an application and says, I have no criminal history, none. Background investigation finds, wow, that's a lie on your application. You do have criminal history. So depending on the circumstances, we draft an order in exactly the same legal language as has been provided to us by the Attorney General's office for a notice of denial based on a material misstatement. That's probably the best example of that. Occasionally the board makes a motion on the record during a board meeting, and we don't have an order prepared, and the secondary part of their motion is to draft the order and have me sign it as the executive. They give me authority to sign it. So internally, we would draft that order, okay, consistent with what the Attorney General's office standards have been for us and our own standards internally. That would be another kind of an example. The board itself never drafts an order. The board itself. That is always done by either the Attorney General's office or staff.
Okay. I think my question is more granular than that. It looked to me like this maybe suggests it can be written or not written. And I can't contemplate a subpoena or a motion or anything else not written. So apparently I'm misreading. Is that fair? I asked counsel.
Where are you referencing?
Number 2.
Number 2? So where it says may be written, signed, issued by the executive secretary?
Yeah, and then the third line, may be signed.
Okay. Because the way I was interpreting that is that the executive secretary could sign. It's going to be in writing, but it's leaving it to the authority of the executive secretary to sign.
Okay, fair. Just clarification for my own mind. Thank you.
What you don't want me to do is to go out to one of your clients and say, give me these records, and they say, I have, and a subpoena, well, we don't write subpoenas, I'm just telling you we got one.
Exactly.
Yeah, okay. Got it.
Not that you would.
Oh, you never know, but yeah. So let's, before we have any other discussion, does the group, if we move forward with this, does the group have any problem with, in the last paragraph, just putting a period after application in the last sentence and leaving off for a motor vehicle salesperson license? Because in practice, that's what we do now. I mean, we do a background investigation on the dealership. And if there's no red flags, through delegation of authority, we issue the license. Okay? If there is any kind of a red flag at all, it comes to the board. And when it comes to the board, we've already done a fact-finding. We've already done fact-finding, and occasionally, through another statute, I make a recommendation to the board of what I think the board should do. It's just a recommendation. The board does what they think is best. But I mean, it's in practice, we're sort of already doing it expanded of motor vehicle salesperson licenses.
My only concern with that was the one I raised last week. As long as that becomes part of the record that can be used if it goes to an administrative hearing. And I don't know if it's an informal fact-finding and you just make oral recommendations to the board, how that would then become part of the record that would be discoverable and you can take it to an administrative hearing if you were challenging a license decision.
So let's step through that, Mike. So we do, I mean, that's what we do. We do fact-finding.
Right.
So we do fact-finding, and the only time that the division, the executive secretary, the only time that I deny a license is for material misstatement or an obvious mandatory disqualifying conviction. All the rest are granted, or they go to the board for those little red flags. Sometimes there's major red flags, but red flags. And then the board makes a decision. So once it goes to the board, the fact-finding has already taken place. It goes to the board, and that's always a matter of public record at that point in time because it's in the board packet. And actually, anyone can do a court request for things that don't go before the board, but certainly they go before the board. So immediately when the background team makes that presentation, obviously there's a recording of that, and then the board makes a decision, discusses it, and makes a decision with or without a second recommendation from me, because I don't do that very often, but occasionally I do that. So does that sort of...
So as long as that it's recorded, becomes part of the record, which can be used in a subsequent administrative challenge, then yeah, I'm satisfied with that. As long as there isn't any off-the-record informal recommendations made to the board on a licensing decision. I see the Attorney General shaking his head over there.
Yeah.
That doesn't happen, which
Yeah.
I appreciate. So
That doesn't happen.
okay.
Okay. So with that, does that set your mind at ease
Yes.
enough to put a period after application and remove that? The for any motor vehicle salesperson license, because it'll just deny an application. That means anything that comes, we would handle it that way. Anybody else? Okay, so let's go back to the top. That will be a numbering change on the title, okay? So we know that's a second change. And then you're suggesting, Leland, that 126104, however that is, that's not a substantive change, that's just a modernization change.
Correct.
All right. So anybody have any problems with those 3 changes? Now, open it up for discussion on any other things that are concerning.
I wanted to go back to the power to control the agenda. We talked about this last week as well. And here's a scenario I'm concerned about. My constituents, the new motor vehicle dealers, disagree with the position taken by the auto industry division over a policy matter or an interpretation of a rule or statute. And they want to raise that issue with the board. And we contact the executive secretary, who's also the director of the auto industry division, and say, we'd like to take this to the board. And he says, sorry, we don't have time on the agenda this month, next month, or any time in the next 4 months to do that. And we're sort of left out in the wind. And I appreciate and understand Leland's constitutional history that he gave last week about the power to petition and call people out for not discharging their duties. But that really doesn't solve the practical problem of how do I get something on the agenda? If I'm an interested party, how do I get something on the agenda quickly with the board? I understand I can come to the board meeting and wait till the end of the meeting and raise it during the public comment and try to convince the board that they should put it on the agenda for the next meeting. But I guess where I'm going with this is I'd like to see something added that an interested party can petition the executive secretary and the board to be added to the agenda for the next meeting. And I don't think it has to be a big formal process, but simply sending a letter to the executive secretary and the board to say, we have an issue we'd like to put on the agenda for the next meeting. Maybe identify what the issue is, and then let the board make a decision as to whether they want it on the agenda or not.
So you're making that suggestion based on timeliness more than anything else?
Right.
Okay. So let me the only thing that is concerning to me about that is timeliness on the other side of it. And that is that I'm just going to interject me. I do the agenda about 5 or 6 days in advance of the meeting someplace. I know about 10 days in advance what that meeting's going to look like. And there are times that the meeting potentially is very ugly as far as time. And what I mean by that is we have significant team reports, and we have 2 or 3 hearings or exceptions hearings scheduled, which require executive session and all of that. So that's my that's one of my concerns, is that if somebody petitions that if it's in rule, I have no discretion then. It's on the agenda, okay? And although CADA would never, in my opinion, bring up something frivolous, once it's there, somebody else could bring up something that is very frivolous.
A certain buyer's agent?
Pardon me?
Is that a certain buyer's agent?
Well, I agended that because I didn't think that was frivolous. I thought that was actually a good discussion. Now, I do know that, being fair with CADA, I think Tammy, about 2 years ago, 3 years ago, we had an item that you guys wanted on the agenda, and I got it there, but it was delayed by 3 months, I believe, maybe 4.
It's a rare problem, but it does.
It happened.
We had an issue, I think, last year in a form. We had to come back 3 or 4 times for, and so that.
McCoy.
I understand.
That's a little bit frustrating from someone who helps people who are heavily regulated by the division, and particularly in obtaining board decision on something. And the power, as I pointed out last week, the power to control the agenda is the ultimate power. And so I am concerned about that not having any checks beyond my ability to appear at the public comment section and request permission to be put on the agenda for the next meeting. And I also understand the need to notify anybody who might be on the opposite side of the issue. Absolutely, because those people should have the right to come in and respond to whatever the issue is. But I am concerned. And again, I'll state that, you know, you have been very fair, Bruce, and objective, but I am concerned about who sits in that chair next time I'm here, and what that person may or may not do.
Yeah, I come in for a second, Mike. I don't remember if I included in my discussion of this last meeting the fact that we do have on the books a way to enter into a declaratory action, okay? I mean, when I parse this mentally, I think, okay, there's all kinds of ways to end up with a good result, and there's all kinds of ways to end up with mischief. And I guess it depends upon what the level of importance of something is. If we're talking about something that does fit a declaratory action, I would think that that's the route to go.
And I have utilized that before.
Yeah.
The petition for declaratory relief.
That won't necessarily get an immediate
Right.
result.
There's no requirement that be put on the agenda either. So.
Right. It would take the usual time to establish a hearing for that. It provides all interested parties the opportunity to join. I mean, that's the mechanism that really ensures all that at a formal level. What I hear you saying is, if it's a licensee who has a legitimate interest in an issue and they want to do something less formal than a declaratory action, how can they get the board's attention if this is an important issue? And, you know, Bruce probably understated the real complexity that agenda creation involves. When he says that maybe 10 days out he has this view and maybe 5 days out he has this more perfected view, the agendas start to be built when hearings start to be scheduled. And that can be quite a lot further out. And some of these hearings, as well people who are familiar with the process realize, can involve an open-ended time frame. So a board meeting that would otherwise look like a 2-hour meeting on the basis of items on, say, Ms. Hartman's, agenda, or Ms. Breeden's agenda, or something like that, suddenly becomes a mushroomed event because we might have an open-ended board hearing that could go for the entire day or another day. And this is the kind of thing that has to go into the advanced planning and then has an impact down the road. So when I hear, someone like you say, yeah, well, I've got a client with a legitimate interest, they need to be heard, can we schedule them into the next meeting? What that says to me is that it's so urgent that it can supplant, a hearing scheduled way in advance. Some of the topics, the very one that you mentioned, the form that you mentioned, that topic was contentious. That topic raised issues that involved the AG's drafting. It involved, the whole history of the rulemaking. It was an unhappy issue at a large scale. And to discuss it required time and the invitation of a lot of parties. So I think it's not easy to picture, if it's a tiny issue that can be discussed in 5 minutes, then maybe putting it into the next meeting is not a problem. But if it's something that's really contentious, putting it into the next meeting could supplant, or add to the time frame so much that the board and everybody's here till 11 p.m. at night. And that's usually not an acceptable course. So it's kind of hard
I
to-
understand that. I understand, and I would suggest a time limit. How about something like, the executive secretary shall fairly consider a request for placement on an agenda that's received 14 days prior to the date of the next motor vehicle dealer board hearing meeting, something along those lines, and sort of drafting out loud, if you will. But yeah, I don't think I should be able to come in the day before the meeting and say, hey, I want to be on the agenda. I don't think that's fair to anybody. I also want to be respectful of the volunteers who serve on the motor vehicle dealer board and sacrifice their time to be on that board and not waste that time. But I also, again, am overly concerned about the authority that grants to someone. And you know, frankly, this agreement may be with the auto industry division. It may not involve another dealer, it may not involve a manufacturer. It may be just a flat-out disagreement with something the auto industry division is doing. And you know, if that person is the same person who's making the agenda decision, doesn't want it to go, then to use your words, there's the chance of mischief. So anyway, I don't want to belabor this point. I don't want to waste anybody else's time on it, but I do think it merits some consideration that interested parties should be able to request the ability to get on the agenda.
Would you have any concern if the executive secretary came back to you and said, can't put it on this agenda, can't do next month because we have 2 hearings scheduled, but we can do 2 months down the road?
Depends on what the issue is.
Okay.
You know,
Yeah.
exactly. I mean, some issues are more pressing than others.
Okay.
Some involve a current fire, if you will.
Mhm.
Others are smoldering and can wait 2 months. So,
Okay.
In court, you'd probably seek an injunction or some kind of hearing that's, you know, really, you know, an emergency type of hearing.
well, you know, one of the problems with representing dealers is everything's an emergency.
It's true.
Well, before we totally move off of this for this moment, Mike, you used the term interested persons. Of course, that's sort of getting us into the declaratory language or something like that. Well, what if it's an outside person? What if it's John Q. Public? What if it's the press? You know, there's certain things that, you know, I mean, if we craft this to deal just with licensees, of course, then that doesn't deal with former licensees who might, you know.
We can't, if we're going to change this, we cannot restrict it to licensees. There's just no way. So let me just throw out this language, and it needs to be molded.
Okay.
And I like the 14 days. I think that's doable, like something like that. So the board permits the executive secretary to set and maintain the board's docket. And here again, this is really rough language. With informed discretion after input from outside agencies 14 days in advance. Something like that. Informed discretion. I have, in the delegation of authority that the board has granted to me, that big document, there's several places in there that we use the term informed discretion. They've got to, when you delegate something, you've got to give that person some discretion, but it has to be informed discretion, okay? So something like that.
Rather than agency, maybe use the word person, so that
Outside
covers-
persons.
Right. So that covers Leland's concern. I agree that it shouldn't be just limited to licensees. And you know, I'm just trying to get my toe in the door here.
Sure.
And I think that language might get us there. So.
Something like that. The board permits the executive secretary to set and maintain the board's docket with informed discretion after input with outside persons 14 days in advance. Now, it's got to be reworded better than that, but something like that. So you're okay if we have to make this change to this rule anyway, this one rule. We're making this one change. We're making a couple changes. So you're sort of okay looking
Yeah, I
at
think
something
that's-
real similar to that.
Yeah, I just want to be able, as I said, get my toe in the door.
Right.
So,
Any other input on that issue? Anything else on this, Frank? Okay. So what we'll need to do is we'll probably need to draft this, and, I mean, it has to go in the rulemaking, the actual hearing, we'll have to, but what we may want to do is draft a revision here and send it out and send it out to this group and say, give us, within 5 days, 10 days, give us back.
and it looks like we've got a third session scheduled on the 17th, so.
Probably.
Yeah, I will review it promptly and get my 2 cents in on it as soon as I see it for this meeting.
Okay, anything else on that one? Hearing none, then the sister regulation is 126504-1B, which I believe is exactly the same, so we would probably have exactly the same issues, change issues, okay? On that, any concern on the power sports side of that?
None.
A couple people stepped out in the hall, so now might be a good time to take a 10-minute break. We've been here a little over an hour, so 10 minutes and we'll come back to 5 and 6. Okay, we're back on the record. It's 10 minutes after 10. And so now we need to look at 126104-3I, which is motor vehicle signage, dealer signage. And we had some discussion about this last time. We don't think, the division doesn't think this is broken, but with the advent of how this industry is changing, what do we do if we don't change it at all, leave it alone, or are we going to eventually have to change it later on anyway? And so that's the dilemma. You know, the whole thing about the height of the letters has to be clearly visible from the roadway. And then we have some of these traditional dealerships, no problem. It's the non-traditional that get into, you know, business parks and so on and so forth, that the signage is a problem because of local ordinances and/or the landlord doesn't allow certain signage in certain areas and certain height requirements, and therefore is the potential licensee at a disadvantage that he or she, they have to move their dealership to a more traditional location. So that's the discussion around this. The vision right now, today, doesn't think this is broken. Comment?
We concur.
Okay. So, hearing none, we'll move that one forward, and the same for 126504-1J, which is the power sport sister regulation. Now we get to 126115-6. I'm out of order here. Here we go. So 12/6/115/6, when the division met on this, we looked at this and we said, it is probably not broken. Our concerns was just the 2-day, the 2 days after services said process. The 2 days may need, it's a time issue thing. I don't know that we have ever had one that really we had an issue with or a problem with. So here again, we say it's probably not broken. If there's anything, it's maybe that 2-day issue.
And I think Mr. Dommermuth brought up a good point at the last meeting, and that's that it doesn't say business days. I mean, because this is more of a regulation on the division than anything else, and so we might want to contemplate if we are going to make a change to this to put in that business days.
There's a problem doing that, Chris. You would have to define business days, and because it's not a plain language question. We have the holiday, I mean, the way the statutes that do use business days get into that is they go through and they say a business day is all, everything but these things. And so they exclude holidays and they name the holidays. And I mean, it's a technical definition to ensure that the state does not trip itself up over the definition itself.
But currently it says no later than 2 days, so if we get it on a Friday, isn't 2 days later a Sunday?
Yes.
Okay. So I think it's broken the way it is, and I think Mr. Dommermuth's suggestion is a better suggestion than what we currently have. That's all I'm saying. Whatever wording has to go into it, perhaps what he says is business days can be worded differently, but I understand where he's coming from, and I think I concur with it's not really feasible if we get something on a Friday that we have to turn it around on a Sunday.
Well, of course. And in our in-house discussions, Chris, we came to the conclusion that something like as soon as reasonably practicable might be the best solution. Because that meets the fiduciary duty of, accepting the paper, holding the paper for a minimum amount of time, and, releasing it appropriately. You can always do extended time frames like 4 days, which would cover all holiday questions, at least at the current moment. But,
We get furloughed again.
From the other side of the equation, Mr. Dommermuth, I'm going to aim this at you. If it was changed to 4 days, would that pose a problem for your clients getting timely notice that we got that notice?
I don't really have a dog in this fight. I just raised this as potential issues because I thought, I don't think business days is ambiguous. I think the rules of civil procedure use similar language. I don't know that it's defined in the rules of civil procedure, Leland, but I don't have any dog in the fight in this. I just wanted to point out the problem that Chris pointed out, which is if it's served on a Friday, then technically you've got to get it out the door by Sunday. And not only is the postal service not open on a Sunday, you hopefully aren't working on Sundays either. So since we're all closed on Sunday, right, Bruce?
Absolutely. We'll never change that. That blue law will remain in effect forever.
We're not closed on Sunday.
So in any event, I really don't, I just pointed out as something that might potentially need to be fixed, and how it's fixed, I don't think matters. I think 2 business days would work. I think most people understand what business days are, that does not include Saturday and Sunday. I think going to 4 days may solve the problem. I don't really have a dog in the fight, so. However, the division, this is a burden on the division, not on dealers. So however the division best wants to solve this, I'm sure we'll be okay with that.
And as much as I like the language as soon as reasonably practical, I actually like that language. That what does that mean?
Yeah.
I mean, what really is that standard? And my practicality may be different than the Attorney General's office practicality. So, although I like the language, I'm just not sure. So I'd like to say maybe that we either say that we change the 2 days to 4 days, and if we want to put business 4 days in there, we put business in there and move forward. So let's, is anybody opposed to 4 days? So if you will give us the discretion when we draft this, we'll put 4 days in there, and we'll give us the discretion of whether or not we put the word business or not in there. And we'll do a little bit more fact-finding on that. Okay? Is that okay? Okay, so that would cover then the Power Sports 1, 2, I believe. And so we'll move those two forward with that small modification. Okay, now we get to 12.6.504.1I, Power Sports Regulation, ANSI requirements. We had a lot of discussion about this at the last meeting on trying to draft language that may be more applicable, because this regulation came out virtually at the same time the power sports became regulated. So it's it's 10 years old, and 10 years ago it was probably appropriate, but today, because there's been some changes in it, so on and so forth. Leland did a lot of research in it, and Jeff and his colleagues have done a suggested rule change that you've probably found on probably about the last page of your packet. So with that, Jeff and Leland maybe talk about things. And Jeff, just so you know, Leland met with Jerry Abood on this issue after the last meeting, and they had some discussion on that too. So,
Okay, good. Let me just sort of tee up the language that we submitted on behalf of our client, the Motorcycle Industry Council. The purpose is twofold. One, to make sure that Colorado rule recognizes the recreational off-highway vehicle classification, which the current rule does not. And then secondly, to draft the rule in a way that I would describe as evergreen, so that as the federal rules change, Colorado rules change with them, so that we're not stuck in a situation where Colorado is one iteration behind what the feds have done. So there's really no other, at least as I understand it, Leland, I'll defer to you, there's no other change, or that captures what we're trying to do with the language we submitted.
What you've seen that I produced was a history, and the nutshell of all this is that in the original contemplations of this law, there was a voluntary compliance component that was adhered to by the power sports industry, mainly those manufacturers who were United States manufacturers. But unfortunately, that was not well adhered to, particularly by the Chinese manufacturers, who saw voluntary compliance as literally the word voluntary means, okay, we can do what we want, and they did. And so what was voluntary needed to become mandatory. Well, that was recognized by the federal government, that was recognized by the ANSI SVIA authorities, and it was recognized by independent states. So all of this began to be this kind of dramatic shifting of law to enable a true enforcement of a mandate. The federal government and the state of Colorado's own law, these things came in a kind of odd tandem way. And so what really seems to have happened when I looked at all this history is that, by the time regulation was being written for this one that we're looking at, there was a mixed action at the federal level. Not everything was completely settled. You know, there was still reference points to the 2001 version. The 2007 version was the one coming in as mandated, but it wasn't all there. So everyone says, well, we got to do, as Jeff says, some kind of an evergreen, you know, thing, but how do we do it? And our legislature crafted two things, and we have to remember there are two things. And they are there's two statutes involved. One is definitional, and that is, I think it's I don't know if it's included in the packet. It's included in my litany. You know, it talks about it's 126502 parent 1. You know, and it specifically looks at what do we mean by that 2001 standard, and then of course it evergreens it slightly, but not well. Okay, so then we get to 126504, the namesake statute of the current rule, and it applies the definition. And so we have to keep those two together. And so then the rule comes out, and the rule seems to contemplate only the four-wheel all-terrain vehicles. And I believe that where that comes from is from the basic material of the statutes, and where they are talking about the definition of the ANSI SVIA 1 2001 being for four-wheel all-terrain vehicles. I raised this in discussion with Mr. Aboud because the immediate concern I had was, in his knowledge, did this statute upon which the rule that he was involved in crafting was created contemplate anything other than the all-terrain four-wheel drive? And he said no, that there were other provisions of law, but that this did not contemplate anything beyond the four wheels. And so then when Jeff submitted the document that he submitted that's in your packets, what's being incorporated there is the two-wheel vehicles that would fall under Part 5, the off-road two-wheel vehicles. And, you know, so the threshold question, which I put to the Attorney General last night, and we both thought about, and invited everyone to think about at this point, is whether or not we're stuck with a scope that is only going to be the four-wheel and, you know, all-terrain vehicles for this moment, because the statutes don't go further. And so that's the question that's out there, the threshold, you know, to consider, you know, even in advance of any other questions, can we bring in this excellent work that Jeff's group has done? And that has to be, I think, further research. Is that what you're thinking too?
Yeah, I haven't had time to analyze it, but the statutory language 126502(1) I think is pretty clear when it says four-wheel all-terrain vehicles.
So, you know, but I don't think we're prepared to answer that. What I was hoping, Jeff, is if your group would, you know, look at that, if you have a response, obviously, or if you would look, if you think there's independent other authority. You know, one of the things that this, did Colorado have to put this in at all? Well, the federal mandate came in. So there was federal law, and manufacturers had to follow that law. And presumably, we would, as an industry, you know, overseer, expect to see that that law was followed and would potentially craft a violation even if there was no rule, theoretically. Did it make it easier for us to do something about it? To have the statute there and the rule there? Yeah, of course. But can we go beyond where we are right now with, to a two-wheel platform as well as a four-wheel? I don't know.
Or three-wheel.
Or a three-wheel. Yeah, the three wheels are out there too. Yeah, you're right. There's no three-wheel there either.
I think three wheels are now prohibited by federal law.
Are they?
Yes.
Yeah.
Okay.
They were causing.
All sorts of mayhem. That's why I was like, three wheels? Are we still doing those?
Leland, you raise a good question, and let me take that back to our folks and have that conversation. I'm not prepared to give you the answer here because I don't know the answer. I gather what you're suggesting is ultra vires. I mean, essentially, if we were to adopt what we've proposed here,
Yeah.
potentially.
Potentially.
Another option, and I'll go back and have this conversation with them, might be to narrow down our suggestion. The language that we have in here, the most current version, might get us there without having to be more specific about two-wheel, four-wheel, recreational versus not. The most current version would be what the feds have done, and I want to think about it some more. I don't think that would take us outside of what the statute contemplates, but maybe it does. So we'll go back and look at that.
One comment on here is I think that you need to make this meets the most current version at the time of manufacture, because the way this reads, if it was manufactured in 2009, the guy selling it in 2017 needs to make sure it complies with 2017's version, which I think is unreasonable.
That's a good suggestion, yeah. Thank you.
Sure. Now, I did raise it, John, absolutely. That was one that came out of our discussions earlier. And when I talked to Jerry about that, he said, well, it's all triggered off the model year. Well, I had to think about that. I'm not as well versed in that concept as other people are. And, I thought, okay, does that solve it if we say it's triggered off the model year, not the year of manufacture?
Either way, model year, manufacturer year, it needs to be 2009, not 2017. A dealer should not have to retrofit a 2009 model year to fit 2017 standards. That's the point. How you get there, that's...
Yeah.
Jeff, can you and your folks analyze that part too?
Yes.
So it's in reading the statute, it's not 12.6, the statute 12.6, 5041I that's in problem. It's the definition.
Definition 502.
Correct.
The way the definition reads.
Yeah.
And it's inevitable, they have to be construed together. So,
This is way off topic, but I'll give you an interesting example or analogy. Our firm does a lot of land use entitlement work, and we did the new St. Joseph Hospital some few years ago, and the city of Denver required that hospital to be built to the National Fire Code of 2012. The state of Colorado hospital regulatory and licensing folks had only approved the National Fire Code to 2002. And they said they wouldn't license the hospital unless it was built to 2002. Denver wouldn't grant a certificate of occupancy unless it was built to 2012. It led to years of change orders on that building, so somewhat analogous. It matters.
Mm-hmm. Oh, yeah. Well, and the fact that you're present and discussing this also illustrates the importance of this whole thing as a reality from the manufacturer clear down to the ground of the used car dealer. I mean, this is truly, used power sports dealer. It truly covers all the dimensions that are covered by all of the boards and the regulations outside of the board that are under the EDO in a sense. Because this is specific, but the concepts have to be in place consistently all the way down or you're in trouble.
I'm thinking about the definition. a statutory definition that is outdated. Any way to write a regulation to that definition? And this one too, that opens up that definition a little bit. Can you write a regulation that opens up that definition a little bit? Because we're talking about, the only thing we're talking about is four-wheel in a year, right?
Well, the
I
thing.
mean, the simple answer to that is no, but I guarantee you, if you go through and look at our regulations and look at the statutes, that's already been done. It has been done in multiple areas, so.
And the thing to point out is that 504(1)L uses the language off-highway vehicles before it talks about ANSI. And if you look at the definition of off-highway vehicle under 502(8), it's any self-propelled vehicle that is designed to travel on wheels or tracks.
Even more confusing.
Yeah. So it looks like 504(1)L starts off very broad and then narrows down very quickly. So something else to consider in analyzing from your point of view.
Just so we're clear, we're not trying to complicate this matter. I think in trying to help modernize the rule,
Absolutely.
it's complicated.
Absolutely.
But regardless, I would say if we look at paragraph 3, it creates an unnecessary limitation on the certification label that no one apparently thought of. I mean, it is not evergreen at all. And to complicate, not complicate, I won't use that word, but to, educate us all a little further, if you get a hold of ANSI SBIA about, what is available, what can we look at? Okay, I was fortunate enough to get 3 copies of 3 different, of the 2007, 2010, and the proposed going into effect 2017. But if someone just calls them up out of the blue and says, can you give me a copy of the standard that's active now? They will literally only give you that. They don't routinely supply to the public a past version. Well, we as enforcers obviously might need to see a past version in order to avoid the problem that John said about applying the wrong thing, doing an post facto application. And one of the things that's always important is that there be somewhere that the public can find the applicable version. Otherwise, it will be a due process violation. So all the government agencies think about this when they put something in as a reference. Where is it going to be? Where do you have in your library? Where do you have that the public can easily get to this document? Well, I didn't try to find it. I don't know if it's on LexisNexis or Westlaw. I don't know if it's in the Supreme Court Law Library. I don't know if any of the federal depositories have this. The kinds of things you'd look to automatically if you're John Q. Public to find the groundwork when you can't find it just on your shelf. So we do have to be concerned, if we're going to be enforcing old standards, that we don't write a rule that says we're not going to be enforcing them, or that we don't write a rule that implies to the public that those are always available just anywhere. I don't know. I found this very confounding.
All right, so it sounds like Jeff and his team will take another look at this and maybe get with Leland and hopefully maybe Jerry Abood and see where we need to go. We'll get there. I mean, I'm sure we'll get there. It may not be perfect, I don't know. I'm just gonna raise that question again. Can we open up the definition to help with this? Can we open up the definition to help with this? I think we've opened up the definition on the next one, big time, so. All right. Now for the really tough one, in my humble opinion.
Howard Cosell would call the main event.
The main event, yes. Now we open up the main event. And I don't know exactly where to start with this. I will tell you that the division feels, and I think probably the industry and the board feels, that this regulation is broken. And in saying that, the division's position is that there is very much a need for off-premise permits, but how do we fix this to be fundamentally fair to all sides? And in some ways, on this particular issue, I feel a little bit sorry for CADA because they get kind of hammered on both sides of this one, I believe, from time to time. So how do you make it fundamentally fair? One of the things that I think Lena and I had this discussion, I think we would like to take this a little bit in pieces, and we'll get to the end, but to start with, we're looking at 1 and 2, and we know that number 2 needs to be, paragraph 2 needs to be redone because there's, I think Mike pointed out last time, there's no such thing as the Metro Denver Auto Dealers Association annual event. We need to change that. We probably need, if we're going to expand and allow for an expanded off-premise permit for the Denver Auto Show and the National Western, because those are 10-day events or whatever it is, that we look at some of the other statewide events that are expanded, really Independent Stampede. I get a call every year from 2 dealerships there. How do we make this work? Because this is it used to be a 6-day event and now it's a 9-day event or something like that. How do we make this work? So we need to think about, if we're going to identify specific events on that expanded thing, we spend some time looking at that. I think the main thing that the division, I think the single biggest thing that the division is, we want a time frame in here. We want whatever that is, 14 days in advance. We are, happens all the time. Somebody comes in the door after the event has started and wants an off-premise permit, or 2 hours before the event and expects us to just sort of drop everything and issue the permit. And we do, because that's what we do here. But as the board has pointed out, dealers know this well in advance, where they're going to put their resources. So there's no reason for there not to be some kind of a reasonable time frame in there. So with that, CADA has sort of done some research into tiered events, and some of that seems very, very logical, and it could very much work, but what those tiers are and how that would look is open for debate. So I'm just kind of rambling now, so let's just look at paragraph 1 and see where we need to go there.
Bruce, before you do that, can I pass out what Troy Allen?
Sure.
Okay. If you guys would just pass this around and take one sheet. Okay?
John, let's John explain who Troy Allen is and what the issue is, so everybody knows.
I don't remember the name of his dealership, but he deals mainly in ambulances. And he was particularly impacted 4 or 5 years ago when we jacked up the price of off-premise permits up to $500, because one of his big things, there's a couple trade shows up in Keystone for ambulance companies. He would always take a couple pieces up of equipment up there and use it as a sales opportunity. When the price went up to that high, it was no longer cost effective for him to do that. So that directly impacted his business.
So I think one of the questions is on the tiered thing, is a trade show different than a tent sale? And should they be treated differently in a regulation? I mean, I think that's where Tim was sort of trying to figure that out. And then is there any need whatsoever, if we're opening up this rule, for some kind of permit, maybe a non-fee permit for display at other places, i.e. the shopping mall? Should somebody have to pull a permit to display at a shopping mall, and then maybe there's no fee? Those are all kind of things that I remember we discussed in the past. And this, I gotta tell you, this, we haven't had in the last year or so, I don't think we've had a contentious issue on this, but wow, 3 or 4 years ago, oh my goodness, this was a contentious issue, so. Debate, comment.
I would advocate losing the word display. I mean, dealers display vehicles go out to Fossil Trades Golf Course, and there's usually a Lexus set up next to the first tee from a local dealer. Go to Costco, there's frequently a vehicle on display. I don't think a dealer should have to pull a permit just to put a car on a display at another location. Obviously, if there's a salesperson there and any sort of sales activity, that would require an off-premise permit. But just to display, I would suggest, should not require a license.
And I'm certainly not advocating that from our standpoint, but that is a question that has been raised to us before. Fact is, it was raised last week by a board member. Do I need an off-premise permit if I display here?
Right.
And can I put a salesperson there? If I get a permit, can I put a salesperson there? And can I put a salesperson there on Sunday? Can I put a person there on Sunday just to answer questions? And so those are always the questions behind he was willing to pull a permit. No problem there at all, because I think they were going to try to do some sales activity, but then he had that Sunday question. So
Right.
Kim.
Yeah, we have talked about this quite a bit over the years. I guess the challenges that we've had in the industry have been a lot of the challenges that you have had from a regulatory oversight standpoint. And just, I want to say at the outset, I think we share your concerns and share the frustration. And it hasn't been mentioned yet, but we ought to go ahead and get it on the table, because it's kind of oftentimes becomes the elephant in the room. And that is when a dealer, it could be a new car dealer, can be a used car dealer. If it's a new car dealer, it's oftentimes selling used cars off premise, which they have to, they may even be outside their market area for what they have a franchise agreement from their automaker, which is probably okay, because all they're taking offsite in those cases are used cars. But we have had instances where a new car dealer, I don't want to mention names or brands or anything, but let's just say a new car dealer that has or had at the time, a footprint in the Windsor area, somewhere around the Iron Mountain, and we won't mention names of dealers, and has gone as far away as Sterling or Fort Morgan in eastern Colorado with that or even another brand. And then we've had, and by the way, when you get those calls, we get those calls too. And as an industry, we're not trying to make carve-outs or exceptions or allow these scenarios to happen. But because you can rest assured that if you have a brand dealer in Sterling and a competitor with that brand who is licensed in Windsor, shows up with new product in Sterling at a tent sale that's supposed to be for used vehicles, you're probably going to hear about it, and we probably are too. We would advise our dealers not to get themselves into that scenario if we know about it in advance. We don't encourage it. We don't incentivize it. We don't try to make exceptions for it. It's just a bad scenario. But while we're on those tent sales, one of the challenges that the regulatory structure has had and the industry has had is when a dealer, be that dealer a new car dealer or a used car dealer, contracts with a professional sales operation, and which oftentimes seem very unprofessional, most often are out of state, and then they get the off-premise permit for, say, 3 to 5 days or whatever, let's say anywhere in Colorado. And this gets outside the brands and whether it's new or used, but this professional marketeering company brings in the staff to do these sales. And then they have to get licensed. So, yeah, if you're talking about the dealership getting the license after the off-premise event has started, that's a problem. But this is a problem even if it's 7 days in advance or 14 days in advance. Almost those professional / unprofessional marketeering companies, I don't think they've ever been 14 days in advance on anything. So, if there was a way to carve those out and just not allow them, I don't think you're going to get any fight from the industry on that. So I want to get those on the table. Those are out there. We share the same concerns and frustrations. Now, when you talk about, and you mentioned displays, and those may be, oftentimes are static displays. And it might be at a show or an event. It might be new vehicles. I don't think these are ever used vehicles. They may be new vehicles, but not at an auto show. They might be at a garden and home show. But they're on display. And the brand, either the automaker or a dealer, has entered into an agreement with, and I'm using garden and home show, but it could be any show. It could be at the convention center. It could be at National Western. It could be at the Greeley Independent Stampede. Do I have that name right?
Mm-hmm.
Or any other place. What we advise, if they do have a person there talking about the attributes of that vehicle, then that can quickly, we think, get into a situation where they may be non-compliant with their own if they don't have that off-premise permit. But then you might have a display, and as I think you mentioned, these can happen anywhere in the state. And, it might be a new car dealer that has an agreement with the Cherry Creek Shopping Center for their brand of vehicles to be on display 24/7, 365. Not that the shopping center is going to be open up any hours, but they don't have anybody there talking about it. And I'm not sure that there needs to be any licensure on something like that. Do you think under the current construct that there needs to be?
No.
Yeah.
So we view that the same, I think. Where the rub is, I think, or where the danger or the risk may develop is those shorter term displays that they may be inclined to have a spokesperson or somebody to talk about the vehicle. And we think that's probably all right unless they get into anything about the price, the value of trades, equipment. Well, equipment's probably okay, but anything about price or what that somebody might be able to buy it for or whatever, and then they need to be licensed and all that. So Tammy has been no longer with us, so in deference to all of her work, Matthew's in that role now, and he has had all this handed off to him. I wanted to do that lead-in. So I think we're probably on the same page on the vast majority of it. I was interested though in just something new, because I hadn't heard it before today, the 7 days or 14 days. One thing that I know, I'm sure none of Tammy's recommendations or research ever got into this, but you might want to consider, because I know you want to be able to accommodate them, and you feel like you're probably backed into a corner needing to accommodate on something shorter than 14 days. Maybe that's where the price differential should be considered. If they come in that 14 days or even 7 days in advance, this is the price, and then you have the more, I guess, code red emergency pricing. If it's like on the Friday before something starts on the following Monday or something like that. And I'm thinking out loud on that because we hadn't really contemplated that before today, but since you talked about the 14 days, I think that would incentivize anybody that's going to do an event off premise to get the licensure done sooner rather than later. So I think we'd be amenable to talking about that if you want to. Is there anything else we need to throw out there?
No, I think Tammy's model is a good place to start the discussion, and
Yeah, I just follow up, Tim. You and I have had this discussion. We had these discussions, heavy discussions 3 or 4 years ago when we were getting in on all sides. You were getting in on all sides from your community, and the same with us. And I think the issue really is what's the difference between a tent sale and a trade show, and there definitely is a difference, okay? But the tent sale is, the issues we had is exactly what you said. The out-of-state sales force comes in, no loyalty per se except to themselves, and there's mischief there and all of those kinds of issues. And then being fair is what the board has done, because this is such a contentious issue, is they've jacked the price up, and we sort of supported that, but they jacked the price up to where it was pretty expensive. And when you jack it up and make it pretty expensive, then you impact the smaller dealers that maybe that's, wow, can I sell enough vehicles here to make a profit and less that amount, so on and so forth. We've had those dealerships, used dealerships, pull permits in the middle of another dealership. We had that issue. But I think then we get into something. The thing we haven't talked about is the dealerships under common interest all going to one location, and then all of a sudden they do this master consignment agreement, which really kind of flies in the face of the history of the licensing regulations, so to speak. And how do we look at that when we have several dealers that say, wait a minute here, I have 3 dealerships in the same campus, and I cross-license everybody, but this dealership can go out and bring 4 dealerships together at one location and do this master consignment agreement, and they just pay for the permit, and they just transfer these vehicles, which probably never really happens, back and forth. So that's another issue that needs to be at least talked about here. So we have allowed the consignment agreements to go forward because the division 20 years ago allowed it to happen one time, and so there's some precedence, but we've kind of got beat up, and I think you have to on both sides of that issue too. So.
Yeah, and I meant to bring that up too, and I'm glad you did. And one thing I left off on those professional marketeering companies that are very, in fact, unprofessional, is that those people that they bring in, a lot of times can't be licensed in Colorado. they've got criminal backgrounds or whatever, and they would make some of our dealers blush if anybody's even trying to license them, and yet they show up at the door to get licensed, you know? And so that's why I don't think you'll get any pushback from the industry on limiting or restricting those, or and I think the pricing that may have got out of line for the small dealer that's on a one-time event was really kind of calculated more on a tent sale that's 5 days long and selling 150 cars at some point in western Colorado or northern Colorado or eastern Colorado or maybe downtown Denver. But then you probably can't get the price on the license high enough to cover all the grief that those events can cause. And yet, at the same time, you're pricing the small, well-intentioned dealer out for a single trade show.
Let me ask you a question. I wish Todd was here on this question, but is there any traction, and if there's not, there's not, is there any traction to limiting the number of permits a single dealer can get in a year? You get 4, use them wisely. You get 6, use them wisely. Is there any traction in that at all? There may not be. I don't know what the unintended consequences of that would be.
I don't think there will be from us at all. Although, I mean, I haven't done a lot of research on that, but I don't know of any, let's say, legitimate newer used car dealers that are doing more than, or that are applying for more than 1 or 2 events a year. There have been some in the past, and those were the ones that we've had the problems with.
Correct.
So I'll go back. I don't know of any legitimate newer used car dealers that are applying for more than 1 or 2 a year. But I don't know that will fix some of the problems that we're also trying to address. I don't know that fixes the consignment issue, because on that, each of those dealerships would need to have that off-premise permit for that once or twice a year sale. So that problem it's not going to fix what the price should be on a single one-time trade show, or maybe a 2-time trade show. So I don't think just to your specific question, I don't think you'll get any industry pushback on limiting the number. Do you, Michael?
Yeah, I think it does make sense.
Tim, your big trade show, the Denver Auto Show, and I really don't know this. I mean, I can check, but I really don't know this. Roughly how many Colorado's franchise dealers pull a permit to go to your show?
And I don't know that. I mean, your records would have that better than ours, but we encourage them. So a lot of the manufacturers have really moved to a model that they would prefer just product specialists be in those exhibits. And so those product specialists are never going to get into the price or trade value or anything. They're going to be just what they're called, a product specialist on those vehicles. So we know of some brands that the manufacturer said, hey, we'll just let our product specialists handle that. You don't need to have any salespeople assigned to the exhibit. And so I think in those scenarios, the number of permits that are going to be applied for is going to drop precipitously or dramatically, or both. There's others that are pretty much, that haven't gone to that model and pretty much dependent on a local sales force to come out and talk about the product and handle that. The number that, and I'm just going to venture a guess, that it's going to be somewhere around 30 to 40 and maybe upwards of 50 Chris, do you know what would have been the all-time high on sales?
I was
mean,
just trying to think of it, and I can't figure it being more than like 60 that I've ever seen, ever. I'd have to
In some
go.
cases, and these will mostly be high-end product, but in those instances, it's usually the dealer that's on exhibit versus the automaker. And then they are the ones that have to staff it, so they will apply for the license, the on-premise permit.
So the manufacturer is sort of driving the bus there a little bit, but the dealer for the manufacturer, brings the inventory to your show. Is that a fair?
Well, now you're talking just inventory versus the exhibitors, or the staffing. A lot of times it's, the manufacturer does rely on their franchise dealers to provide the product in the displays. And some exceptions are that it would be if they're bringing a pre-production car, or if they're bringing, certainly if they're bringing a concept car, or if they're bringing something that is not widely produced and the dealer may be at risk of not being able to provide it. But that a dealer could provide all the product for an exhibit and still not have any licensed salespersons off premise to staff it if that automaker is staffing it with product specialists.
It may be an unfair question, and this is not a setup question, but how much sales activity happens at the Denver Auto Show?
Directly, very little. Probably the only ones that we see or hear about would be on Highline product. And I'll get into names, but just because it is limited to these and it's specifically about these, and that's like a Ferrari. We've literally had somebody come down and for the Ferrari dealer, the Ferrari dealer has one of this model and it happens to be on the floor of the Denver Auto Show, and a customer comes in and wants to buy it. And these are people that don't have to worry about financing. They can write a check for it. I don't think they can pull the cash out of their billfold, but we have had Ferraris literally being rolled off the floor of the show. We've probably had some Porsches over the years that's happened to as well. Maybe some Aston Martins. But the flip side of that is that the show is really is intended to be a resource for consumers who are in market that may want to buy that car, not today, but next week, next month, or in the next 2 to 3 months. And they're not planning on going to the show to buy the car. There have been shows in years past that have been what are called selling shows. Portland was one. And
I'm sorry, say that last. What was one?
Portland.
Okay.
Portland International Auto Show was a selling show. So they would literally have, and I don't know exactly how it works because I've never been to that show or a selling show, but they would have F&I offices in the back, the way AutoNation has them in the Pepsi Center, so that they can deal. It's interesting though, and I'll use Jack Gerhard and his product as an example. And these are the Highlines, not the Fords or Lincolns necessarily, but the Highlines. He has said that over half of what he sells throughout the year are from customers that saw the car for the first time at the Denver Auto Show. And so he's building leads and selling those down the road, but he's not selling them at the show, but he's selling them because of the show.
I still go to the car show every year, and I don't want to speak on behalf of the new car dealers. Since the manufacturers have certainly brought in more product specialists over the years to just talk about what their cars are today and their technology, I think there's been less licensed salespeople that the local dealers have had to provide to that show. May or not be correct. But a licensed salesperson who's required by their store to be at that show, they're there to sell cars. Now, they could be talking about product knowledge and technology and everything else, but if they get an interested individual who thinks they want to buy a car, they're gonna do everything that they can to sell them a car. Maybe not that day, but
Right, so they're
subsequent
gonna
days
be
at their
giving them the
stores.
card and the address, so they can come in. Can I schedule an appointment Monday?
Yeah, let's, you know,
It's in their DNA.
absolutely. It's just what they're doing.
And I think if I can address Leland very quickly, you sent an email our direction with a draft asking if that was something we had seen or we're still working on. I found one of the files that Tammy left me included sort of justification up to the point where the copy you had sent. So I think not only are we on the same page, but I think that's as far as we've really made it. I don't think we've moved beyond that necessarily yet. And this draft does encompass most of the things we've been talking about here this morning.
And I just want to back up. I think it would be unfair to limit the number of off-premise permits, maybe not for the new car, but, you know, some small entrepreneurial independent dealer, whether, granted, you currently don't have that, somebody selling teardrop trailers who wants to work all the rodeos and trade shows on the western slope, because their business is really defined to a season, and they start in April and they're going to end in November, and they're going to hit 20 different trade shows, tent sales. That's driving their business through the winter months that I think would be unfair to put a restriction on how many one could get. Some specialty used car dealer that's selling some type of car that wants to hit certain events, who's going to go out there and they get results and they want to continue to do that. So I don't think we should have a limit on that.
One of the things that did come up at the last meeting, and certainly it's relevant now because Tim has raised it again, but virtually any time that we restrict the ability of a company to exercise a reasonable business option, something that could be done anywhere else in the country, we have to have a good justification, and it has to make sense as a justification. It's got to fit within, the mission of the statutes, and if it's protection of the consumer, okay. So if that's a question you ask right away, you say, okay, if we limit the number of permits, how does that protect the consumer? Well, maybe it doesn't. Maybe it actually runs counter to protecting the consumer, because the consumer in Podunk who might see that car at that place suddenly can't see it at that place because somebody's having to choose. Do I go to Podunk or do I go to, some other place? So, right there's a restriction that may not easily have a rational basis. The tent sale people that are, I won't name the corporations that we all know that, are national in scope, that these are the professional sales forces that we've had trouble with coming in too late, and things like that. If we absolutely restricted that from happening, I think we'd see an immediate challenge from DORA on this restricting of commerce under the Commerce Clause and under the statutes in the state of Colorado about free trade. Because it's a reasonable business option to allow a subcontractor to perform the functions of your business. And now what we do have the handle on, of course, is the handle we always apply, which is they have to be licensed. And so the critical question is how do you get them licensed in time for them to have their tent sale? The novel idea that I heard today was the idea of having a higher price based upon the arrival moments of someone to get their permit. The only thing that we run up against that I immediately can think of is that if they come in on Friday at noon and they're willing to pay $100,000 for their permit, I'm just throwing this out, okay? Do we have a way to staff the actual activities to provide them with salesperson licenses for the next day, for example? I mean, we're a state government agency. Our employees go home routinely, at least most of the staff that be licensing, would go home at 5 p.m.
By God, that's gonna change.
When we get that $100,000 that we'll never see. But honestly, this can be a problem because we're not able to just gear up for emergency activities as an agency, as a matter of planned performance. And that's what it always turns into when they come late. It's an emergency. We feel like we've got to do something, but what can we do? And so it's, you know, we violate our duties as public servants if we don't follow the law that we follow for every other occasion. But we can't bring people in as overtime to get it done. Am I right, guys? Chris, can we?
Well, and the other problem is that there are people who've patiently been going through the process that gets set aside while we deal with emergency.
Yes, exactly.
Which is my biggest frustration, is people that are doing it right, people that came in early and were working through the process, suddenly get set on the back burner because somebody's got an emergency.
Yeah.
I asked this last week, or whatever that was. Do we have the statutory authority to put a 10-day, must be 10-day prior to the event to obtain your off-premise permit in regulation? Do we have that ability? And I don't think you get pushback from anybody.
It's a great question, and it's a great question because I think we think that this off-premise issue is in the wrong place to start with, so that I don't know that statute where it's at, because it's a definition that addresses that. Can you expand? Is the board able to expand a time frame that isn't addressed in the statute?
I mean, certainly that with the new fingerprint from these out-of-state marketers will limit the mandatory disqualifying salesperson or whatever else that may come in. We'll stop that, right? The one who couldn't get a license otherwise, whether mandatory or criminal, you know, that's like, you know, ultimately the dealer, the licensed dealer who's bringing in this outfit is going to be required to deliver title, convey titles, disclose material particulars, salvage. That burden, long after the outfit is gone, whether their salespeople were criminals or not, that burden is still on them, right? And if the hooligans, that some of them, you know, would embarrass the dealer, wouldn't hire him to begin with, doesn't perform all that, well, they're leaving that dealer high and dry. So, you know, to me, if we can get a 10-day in place, certainly solves a lot of those issues.
And I'm not a lawyer, but I will say that a couple of the other regulations that we are tackling in this very group are putting time periods in.
Yes.
So I think it is acceptable, and I think it is something that the board can do in a regulation, because they've done it in the past, and it's in a couple of these ones that are in this group.
Well, the other thing that's probably worth addressing too is what happens when we catch somebody at the stock show who doesn't have the off-premise permit. Because, I mean, right now it's go down to the office and pay your $50 late fee and you get your off-premise permit. If that's the only thing that's going to happen, you're out of state slasher guys, $50, okay, whatever. I mean, so that's something to look at in this grand scheme of things too, because you may incentivize the guys to are missing that date. Well, let's see if we can just slide through and not get caught.
Yeah, every one of these issues we have some
Real world experience.
some example that really did happen.
Yeah.
So.
And I've seen both. I've seen the person who didn't realize that they didn't realize they needed an off-premise permit set up at the stock show, and I've seen the person that literally they knew they needed it and were hoping they wouldn't get caught.
I think they both have to leave, personally. But
Well, logistically, that gets tough in the stock show too. I mean, when they get set up in that event center, logistically getting somebody to pull their trailers or pull their vehicles out of there.
Yeah, we, on the backside of that, about 5 years ago or 6 years ago, whenever we have these off-premise events, we send staff, not every single time, but most of the time, just to walk through, where's your permit, blah, blah, blah. We send staff to the Cattlemen's Association event, and there was a trailer dealer there from out of state that didn't pull a permit, and so we said, stop, you're done. Go down and get a permit. Screw you, we're closing up and we're leaving. So went straight to the governor's office. Governor called the executive director. The executive director called me. What are you doing? Discussed it through the process, and the executive director was not. This is a couple of executive directors was required by the governor's office to write a letter of apology to the Cattlemen's Association, because the Cattlemen's Association said we'll never come back to Colorado. So I mean that's wow. I mean, wow. So that's a real life example.
I think we get called on that one too.
You know, thinking outside the box again. I mean, there are tools that the board, through the exercise of its own process, can use. It seldom does. And one of them is to issue a cease and desist order. Occasionally, the board has delegated the authority under some circumstances for the executive secretary / director of aid to take action in its absence under the qualified circumstances. So a strict delegation of authority where it has to be evaluated on the facts at the ground at the time. If that were to happen, it might be possible to effect a cease and desist order. Now, what does that do? Well, it's sort of like certainly a legal slam if that were the case, but I'm not sure what it would mean as far as, you know, enforcing it. I mean, we don't have like a lot of people that are very large with very many guns, and you know, can't just haul them out of the place, you know. So I wouldn't know what it would mean, but I'm just saying that, you know, we're starting to think about what would de-incentivize bad behavior. You know, the ability of the board to have some immediate tools available to it through delegation would be a place to look, you know. But again, boy, I tell you, this is hard. I don't know how that would work. And John, you had these experiences with these guys who didn't understand they had to have one. Okay, so, but how, you know, what's the fact finding behind that, you know? They say so, right? Yeah.
Well, some of it is the interaction we've had with the dealer. I mean, a brand new dealer that's had their license for 2 weeks, that's kind of reasonable that they may not recognize that, especially if it's a dealer from Sterling. I mean, that's a reasonable answer. The guy who's been in business for 25 years that we catch him every year at the stock show, yeah, you know that they know that they're supposed to be.
Right. So, yeah. So it becomes more reasonable if you had a legal instrument available to use on the second case, and wouldn't use on the first case. But I just don't have an answer. But I thought we'd start thinking further afield than we ever have. We want to open this up.
The issue that I have is if we put a time frame in this, I'm back to the time frame. We put a time frame in this and say whatever it is, 7 days, 10 days, 14 days, whatever it is. And then taking Tim's sort of suggestion is if it comes in after that there is some kind of a graduated fee acceleration or something like that. I don't know that does anything for the salesperson issue. And the salesperson issue is an issue here for that because what happens is when people show up to the front counter here, they're taken in the order that they show up. And even with fingerprinting, on the surface, if they don't disclose anything and we send their fingerprints off and we don't get the response back for a day, we're going to issue a temporary license because that's the practice. And CAD and I debated this this temporary license a lot in the sunset review because we were on different sides of a different issue, but the temporary is, in my opinion, is the root of all evil. But we have it, and it's the practice of the division in the industry that we do that. That's the whole issue with those out of state, is that temporary can still be issued. What happened is when the really bad one came in that Tim's aware of, that we had that really bad one in Pueblo. When that one came in and those people came out of, I think they were out of Arkansas or something like that, 10 or 12, and we ended up, there was 8 of them that, there's no, we only licensed a couple. But what happened, the result of that is I made an internal thing, an internal policy, and said, we will issue no temporary licenses from now on to any persons with an out-of-state address. They can still go through the licensing process and still get a license, but no temporaries. Well, that lasted about 4 or 5 days. The AG's got wind of that, and the executive director got wind of that, and said, on what authority do you have that? And I thought, well, just because I'm Bruce Suloff, it didn't work. So that's the whole another issue, is that can you deviate from a practice that has been there for years and years and years for this issue? It appears that you can't. So the 14 days, 10 days, whatever it is, can solve maybe somebody walking in the door the day of the event and getting an off-premise permit. But I don't know that it's going to solve the salesperson side of it. Now, most of the tent sales, they're using their own people. It's not a lot of times that they're using this. We haven't heard anything recently. Have you had any, Tim, recently that?
No, it's been surprisingly quiet. The only ones that I'm aware of, let's say in the last few weeks or months, are the type that you described earlier on the multi-dealership group that's bringing all the inventory to one point.
And so they're bringing their own licensed sales force.
Right. And there's 3 large groups, and I guess it's probably the 3 largest groups that operate in Colorado that do that on some type of a scheduled basis. And they are very professional, so we don't usually, I hear about them in the news or on the news, but let's say on the radio, but not on the news. That's the best way to put it. Which is the best way to hear about it.
I don't know that we've had a complaint on this issue in a long time, on that particular issue. So.
Right.
Matthew, you haven't had tons of time to look at this, but does the tier system have validity in your mind as somebody new to this industry?
I mean, it looks like it does. So, just from someone who had very little interaction with cars when I came here, when I see something being displayed, I wouldn't even imagine that it's for sale, so it doesn't seem like there needs to be somebody permanent there to sell it. And in the draft that Tammy left, she sort of delineated that to the extent that people are there, sometimes it's just for security, to make sure nobody's running through the mall and dives into the side of it, or just for information about where you can get it. Because it's also not immediately clear to somebody who doesn't know cars what type of car it is just by looking at it, unless it's one of the major manufacturers. Those are a little more obvious.
Did she have that, and I don't remember, did she have like a tier 3, no license required?
So there were 2 tiers for limited and full, but part A, which was above that, did make an exemption for display-only events from the permit requirement. So you would not need either limited or full. And I think that would address sort of the low lying fruit anyhow. And then I suppose for something like the auto show, there are some folks who only have sort of product experts to sort of explain how things work and what the features are and how they're being incorporated into drying technology. And then a limited selling where there would be salespeople there to discuss things like price, which the product experts couldn't do, but there would not be on-site consummation of a sale. that would be something entirely separate. And I think that's where the tier comes in. And I think that would be fairly useful, because then as a manufacturer, you have a decision to say, do we want to pursue limited selling, or do we just want to display what we've got and assume that people will come to us throughout the duration of the year?
Tim, I'm gonna put you on the spot. Do you have the bandwidth, do you have the bandwidth to sign Matthew and Michael sort of this project to draft a regulation on this issue? A proposed regulation? I mean, I really do think that for the most part, the division and CADA sort of agree on the issues.
I agree with that, and to the larger question, I think we'd be fine with that. We probably just, and not because of any change, but just because it's, Tammy's work on this probably dates back 3 or 4 years.
It
It
does.
dates back to the time we had the problem in Pueblo, the
It does.
problem in Sterling, the problems in western Colorado. So we probably need to, just so that we have, I guess, a CYA on our own operation, cast the net again and just say, hey, this is going on and this is what it's going to look like. And since Michael doesn't know what he's getting wrapped into here.
I get volunteered.
I just made you some more money.
He did that. Be on commission.
So here's what I'm thinking is, I mean, this always falls on the division, and it's part of our responsibility. I have no problem with that. But we are really thin on this rulemaking thing. So being that Tammy did so much work on there, if we could see a draft from all of you, the 3 of you, on
Updated draft, yeah.
an updated draft on what you think should be in this regulation having to do with 1 and 2. And Mike, taking the word display out, I totally understand that. Off the top of my head, I can't see a reason why we would oppose that. Consecutive, I have a problem with consecutive. We've all had a crumb. What does that word in number 2? What does the word consecutive mean? And do we add things to number 2? Do we add some more events to number 2 that are more than the 6th day? Should a sale be limited to less than 6th day? A tent sale should be limited to less than 6 days. Should it be a 4-day event? Or do we just leave that alone?
Yeah.
Okay. Do we add more? The Greeley Independent Stampede is the one that comes to my mind because we've got two franchise dealers. One of them sponsors, has a big sponsorship up there, and they pull 2 permits is what they have to do because it's not listed here. So they pull a permit, and then they
Use Sunday as the break.
They use Sunday as the consecutive break thing, and then they pull the second permit for like Monday, Tuesday, Wednesday, or something like that. So, I mean, there's a way around that, but they're paying more money for that, which it seems to me like since that's a longer event, maybe that should be included too. What else do we got? We got the National Western Stock Show, Colorado State Fair. We need to rename your group. Is there an Independent Stampede? And is there any other ones that are lengthy events that we add to that? But the consecutive thing is problematic, and it always has been for us trying to figure out what that really means.
Does anybody have any issues with the time limits that are in 2B? Application for the permit 45 days prior, and salesmen have to be licensed a minimum of, it says 2 weeks, should say 14 days prior to the event.
Where are you seeing that at?
2B.
What are we
But
looking?
we don't have Tammy's.
Yeah.
Sorry,
Oh, okay.
Tammy's work,
That
I'm
was
sorry.
in Leland's submission, I thought.
Okay, so what was the timeframes again? Mike, what were the timeframes?
Application for the permit 45 days prior. Salesperson must be licensed a minimum of 14 days prior to the event.
I think the 45 days may not be fundamentally fair. I mean, that may be too long. I mean, what adversely impacts us is when they come in a day or 2 before or after the fact. But
45 days should give you Mr. Jackson's early bird pricing. 5 days before, you get Leland's $100,000 pricing.
And so, you know, I wouldn't be opposed to 45 days, but we may get a lot of pushback on that, because that's a considerable amount of time.
Yeah, that's a lot of time.
And the salesperson thing, if we can get away with that in a regulation, I'd really like that, because that solves that problem. That really does solve that problem. It does.
That'd be my hope.
Or we could make
Stage
them the
events,
same.
The 45 days, that's a no-brainer, because they're done a year in advance.
Right.
Right? But the small guy that gets wind of some event that, he's gonna be there, and gosh, I might as well, do something, that makes sense, then they're limited from that. So the 45 days is too much of a burden across the board.
Maybe they should be the same time period, 14 and 14. You know what I mean? Because if you're going to come in, you're doing the planning, so you know you need the permit. You're kind of already thinking about what your staffing is, or if you're going to bring somebody from out of state or whatever. So maybe they should be roughly the same.
And just on that point, and we certainly understand that Friday before us, Monday event or whatever, but since we hadn't had the 14 days before our discussion or any early provisions, okay, how would the division be if it was 7 instead of 14?
Well, it's nothing now, and we're surviving, so, I mean.
Because I think at 7 days, you can make a real case for it. You can have a price differential. Anybody that didn't make it, they'd have nobody to blame but themselves if it's been widely distributed and informed.
And then I don't know that we can, I don't know how we would address the price thing, because that comes in play in a totally different statutory area, but maybe there's a way to say in there for 7 days, anything after the 7 days.
Subject to the $50 late
Subject
fee.
to a late fee as determined by the board, something like that.
I'll tell you where, and all of this has really been on the dealership license for off-premise permit. And one of the things that Leland mentioned and you referred to was don't know if you can do anything on salesperson. I mean, salesperson license is a salesperson license, but what would it work to have? And maybe it's more of an internal policy versus a rule, but if it is a salesperson just being licensed for the off-premise event, then that could be 14. I mean, I think 14 days probably locks as many of those out as a requirement for getting or qualifying for it.
Never thought about that. Right in there, salesperson's licensed strictly for this event, for the permitted event?
Yeah, because, all the dealer groups that are legitimate dealer groups, the ones we've referred to that have the central sale twice a year, they're all using licensed salespersons anyway, so they're not gonna fall under that anyway.
Correct.
Right.
That has some merit. Write it in that way.
Yeah.
That has some merit.
Yeah, because these out-of-state folks would have to fly them in to get fingerprinted, and then they'd fly back home, and then 14 days later come back for the sale. So that may dissuade them from wanting to use those
That may be the
folks.
answer to a lot of the problems on the out-of-state.
Yeah.
I like that.
But typically those out-of-state companies that they do this for, that's their business practice, they're aware of the regulatory requirements needed.
I don't know, Steve. Because if they're
Maybe they'll
operating,
comply with them, yeah.
some of them are in Tennessee or Arkansas or wherever. I think one of the companies that's caused a lot of problems is out of Tennessee. And they come in because it's a new or used car dealer in western Colorado brings them to Colorado. And they've been doing their last 20 events have been in the East Coast. So I don't know that talking about bandwidth, I don't know if they have the bandwidth to keep up with that. That might.
Yeah, and we still have roughly 22, 23 states that don't license salespeople, so they can just fly into those or go into those states unrestricted. But the one that we're talking about, you were just off the board a couple of years, was pretty horrific. It was a pretty bad we had like 2 or 3 of those people had mandatory disqualifying convictions, and then some of the other ones had major felonies. There was only like 2 out of the 12 that got licensed. And then the dealer, bless his heart, he just sort of wasn't paying attention. He just turned his event, he was just contracted with us and turned his event over. I mean, there was nothing malicious on his part. He just assumed that this was going to work. And then all of a sudden, we said no. CAD jumps in and says, ooh, you know, and so then he is left with having an event that he can't staff properly because, you know, so.
He had the ads were out and he couldn't get a sales people licensed.
Yeah.
Because he was trying to license all these out of state.
It was a pretty horrific example. So my question would be, at least on this issue, can you guys take a look at 1 and 2 and kind of morph this discussion and the discussion over the last few years and come up with some, you know, a proposed rule specifically for off-premise and these events? And can you have that done by close of business tomorrow?
Bless your heart.
So I really, because of all the work that you guys have done in the past, and I'd really like you to try to take that on and just see what that looks like. And that will give us a great place to start. Now, when we disband here for today, we'll try to figure out a reasonable date for you to get something back. Reasonable, okay? So, okay
Bruce,
with
could
that?
I ask to be included in that
Absolutely.
circulation, especially to the extent that power sports are going to be dropped in on a parallel?
Absolutely. So do we want to, when they send us their draft, we turn around
We'll give it to everybody.
immediately and send it to the entire group? Would that work for you guys saying it's, okay?
Great.
All right, so let's move on to number 3. Paragraph 3. Books and records, excluding financial, shall be open for inspection between Monday, Friday. Board and its agents and representatives with cause, including ongoing investigation, compliance, audit, strong complaint, order the board. All records, including financial and tax returns, shall be provided upon subpoena by the board. So just a point of kind of clarification here. This is the subpoena by the board is delegated to me as the executive secretary. But under new 12.6.105, under sunset, I have the ability to issue subpoenas as the director. And I'm just not sure what that means exactly and the differences between those, but I think I would rather, for dealer records, I would rather stay with this as the delegation from the board acting as the executive secretary, because that part has worked, and I know that you guys have some concerns with removal of that, but the actual subpoena has worked, and your clients, your clients, our customers have, in the most part, have reacted positively to when we give them a subpoena and give them, what are we giving most of them, 20 days? 14 days? 14 days in advance. So anyway, number 3 is open for further debate, discussion.
John, is it on the original issue that I raised last week? Do you always want the originals, or do you only need those in those types of cases where there's questioned documents?
Well, the problem we run into is sometimes we don't know we're going to be dealing with questions documents until we're actually looking at them. We always want the originals first, and if for some reason we're not going to need them long term, we're good at giving them back as soon as we can. But it's to say only in certain situations, I think that's too limiting, because you'd be surprised how many times we go in there looking for one thing and come across something else as part of the investigation.
So you always want originals?
In general, yes.
Then we get into that thing, Michael, we talked about is when they become electronic,
What do we do?
they're never going to be originals anymore. So, thank you. So does that mean that if they're electronic, let's say that the dealership does a nice job of scanning them in and they become electronic, does that throw out the question document expert from making good evidentiary decisions around that?
I've never been involved in a question document case on an electronic record. That's a really good question, Bruce. I don't know how they would go about doing that.
I mean, most of the time you're looking for pressure in certain areas and those
Right.
kinds of things. I mean, you're looking at some things that probably electronically you could still see, but pressure points and those kinds of things you probably
You
couldn't.
certainly can't date the ink.
Yeah, true. So, I mean, the industry's headed there.
It is.
I mean, it's headed there at light speed.
Right.
So then that whole thing of originals versus copies is 10 years from now, there may not be such a thing as an original document unless we get there within 5-7 days after the sale. So,
I think there's some dealers that don't even actually have paper. You're signing a little pad and that's.
The DocuPad system, yeah, the
Yeah.
Criddell DocuPad system's in use in a lot of dealerships.
and just let me say one thing here, and I got to be real careful how I say this. We license $800 or $900 dealerships, something like that, of which 238 or whatever it is are franchise dealers. So we license the whole gamut. And be careful how I say this. Is Silterhar Motors liable to change after the fact a document, knowing that if they do that and get caught, they could lose their franchise agreement? That would be a gamble that they would be a risk that they would take, changing a document. Therefore, us getting copies, But would XYZ Motors in a certain area of Denver be more likely to do that when they know that there's a problem? And I just got to tell you, the answer to that question is yes.
Yeah.
And so we've got to figure out a way here to be as fundamentally fair to the entire licensed community in this regulation.
Right. What I would like to see, I think, added to this would be a provision that the dealer should have access to the originals as well. Because frequently a charge is an affidavit of probable cause is issued, and the dealer's got to have equal access to that evidence to be able to defend himself, which frequently involves having their own document examiner review the originals. That actually came up with us in
Yes.
this case, Bruce. And so, something to do with that any original file shall be promptly returned to the dealer or made available to the dealer for its purposes upon reasonable notice and request, something along those lines.
Is this not
We do
already
that
covered as
anyway.
part of the APA for hearings?
I don't know, John.
I don't either.
In front of me.
Yeah, I mean, during the discovery process, if it's over at the Office of Administrative Courts, there's generally the disclosure process and discovery. And for original documents, at least in my previous position at the AG's office, if there was a request to view the originals, they would be allowed to come in, look at the documents with some type of staff member just being present to make sure no documents are removed. So.
Well, in the case of what Mike is, and I understand that, is we have our question document examiner, and in his case, his counsel is that if we would have went to hearing on that particular case, he would have wanted to have their expert look at the document too. Well, for their expert to look at the document, how does that happen? Does that happen by their expert coming in here and spending several hours here? Possible, but what happens if there needs to be some kind of lab test? Yeah, how does that work? I don't know. That's a Great question.
You know, and then-
Well, and John, your response assumes that there's an affidavit of probable cause. What if the dealer needs access to the records before there's an affidavit of probable cause? In other words, the investigation is ongoing and the dealer wants access to those records. The APA hasn't kicked in yet.
Yeah, but the question is, do they need the original document or a copy of the document? Because if it's just needing to see the document to, say, deliver title, a photocopy of that document is going to be just as valuable as the actual original. And in general, the dealer is always going to have an opportunity to make those copies before we ever take it off site.
You just don't want to let go of those originals, do you, John?
No, to be honest, I mean, it's, from our standpoint, if we're looking at prosecuting it, yeah, we want the original document.
And I will say my clients frequently want access to those originals. So, I think that's where we're going to have to part company.
Yeah.
Well, there's obviously a way to have it both ways. I mean, when we take in documents for investigation, those boxes of the files, they're not, going home with the investigator. They're sitting someplace where there is an accessibility with an appointment, I would imagine, and with some staff member of our own available, which is not always easy to do. But, in the same way we'd have to do that for other record reviews, I mean, it's always possible. I mean, do we need to put that in a rule, or is that a procedure? I mean, I don't know what right now has happened with our staff in the past, but.
Right now, we're very accommodating. I mean, if somebody needs something back, we give it back to them.
Right.
Unless we have
And so what's the problem with writing that in the rule?
Yeah.
That's all I'm saying. And I just propose a reasonable request from a dealer for access to his records that were subpoenaed should be accommodated, something along those lines.
I have no problem.
That's all.
I don't have a problem.
I'm looking for a balanced approach here, not a one-sided thing.
I have no problem with that at all.
Yeah.
And then we'll debate at some point in time
What
whether or
happens
not
to
we
yeah.
actually need the originals when it,
Yeah.
With electronic records, this all becomes meaningless.
It does.
We have many dealers there are many dealers who still aren't there, may never get there.
I have no problem with
Yeah.
writing something into this regulation that way, so. And we are, with very rare exception, the subpoena power that's delegated through the board to me, with very rare exception, do I sign a subpoena? We had a big discussion, supervisor discussion on this probably a year ago, where I was doing some of this and I said, no more, you have to justify it. Where I very, very seldom do I ever sign a subpoena that's not 10 to 14 days in advance.
Right.
And so we just say, and dealers, sometimes they deliver that, and sometimes we come and pick them up. I do want to say that the exception really does need to be there if we truly believe that if we don't get that deal jacket this day, there's a chance it's going to be altered. Okay,
Right.
I signed one yesterday. It's the first one I signed in a long time because we thought that there could be, the investigators came to me and said, "Ooh, we think we need this immediately." And they justified it and I signed it, so.
Certainly recognize, what did you call it, in Quantico, exigent circumstances?
So are you, is CADA generally okay with this if we address this?
Yeah.
If we
absolutely.
address that
Right.
issue of,
There have been issues on originals in the past. I think last 3 or 4 years, there was an issue on taking original files. But I think as we go more and more electronic, and we have the 10 to 14 day advance notice, so we can make copies of whatever we want, and then have access to any originals taken, I think we will be satisfied.
okay. So we just need to write that one sentence into there that.
Exactly.
Okay. So we can do that. Now, number 4. I don't remember what the issues are on number 4.
I don't have
So the
anything.
Tammy McCoy version proposed deleting the entire last 2 sentences.
Starting to do with subject.
Yes. Yes, sir. And I don't know what her thinking was there.
Well, it's probably to allow having a Boulder franchise and then Flatirons franchise is two different, under the same license.
There's a separate rule. I don't have my rule book. So it says the dealership's, the second location has to have that dealer's same name posted there.
Yeah, Bruce cited that rule to me recently, and I can't remember what it was. It was in the definitional section, I believe, wasn't it, Bruce?
I think it may be in the 104.3G.
I don't remember. I remember what the issue was, but I don't remember where I might have just made it up, so.
No, you didn't, 'cause I actually, well, I still had you on the phone and made sure
No,
you
you
weren't
can't
pulling my
answer
leg.
I gotta take a quick call here, I'll be right back.
Chris, can you recall a situation where the dealership was being denied getting the original back?
No, only when it's been at Bob Hops for writing analysis. It's like, it's currently with the handwriting expert.
And he's usually a pretty quick turnaround.
He is a very quick
Amazing.
turnaround. We're very lucky to have him.
Yeah.
Yeah.
Oh, I mean, you're not gonna bring test sites now,
Prevent it from growing.
I'm just thinking, do we really need to just add stuff to it to cover every situation? Maybe say no.
Yeah,
Rule, on paragraph 12 of it, it talks specifically about, that the principal place of business, and they have to have the additional locations have to have the same name.
Right.
So I would assume Tammy was merely thinking it's a redundant feature, and.
Well, yeah, but, and Bruce, we've talked about this before. We, just from an industry, and I can't speak for independent auto dealers or the others, but from a new car industry, we favor a single license per location, and if you have another location, you get another license. And that was always the principle before, and we'd like to get back to that. And
You don't like the additional location? Yeah, we have some real issues on the used car side with additional locations from time to time.
I'm aware of some of those. It's mostly the mega dealer concept, isn't it? Like,
No, well, we've had some that they have a principal place of location, and these are generally smaller dealerships. They get a second location, and then all of a sudden, the second location, we don't know who, they're not keeping hours over there. They have some inventory there, they're not open. We go over there, or they send somebody over there, and then all of a sudden, the furniture's all gone, but the cars are still there. And I mean, it's kind of some of those issues, so.
well, but you also, I mean, I would say the industry, we've got it also on the mega used car dealers side.
Yeah.
And when you think about it, I mean, if, we don't want to name names, but I think everybody knows who they are, but, and they're good operators for the most part, multi-state and all that, but they're getting one dealership license, one bond, and that bond's not high enough to begin with. We can all agree on that. I mean, but making it any higher would drive out some small operators. It's not going to drive out any of the big operators. But then they put additional locations on that same license, and that was, we don't think ever meant to be. That was never intended.
We don't know how dealership number one got to what they are. So it happened a long time ago. That's the description of dealership number one. All on the same campus, totally separate franchises, but they're all under one one number. One bond.
So we would work with you to fix that. I mean, I think just in conversations in the past, that's where we've been on the same page on it.
Yeah.
And that touches many things and might require statutory change, right?
Right.
So,
And I think I don't have the statutes in front of me, but additional locations are contemplated by the statutes themselves, not just regulations. This
That is
wasn't
correct.
a board-created problem. This is a problem that was created in the legislature probably many, many years ago. And the board has just tried to tighten up the regulation with the adoption of the regulation. Is that accurate, Leland?
Yeah, this is this huge gummy mess.
Your favorite.
Right, I mean, yeah, you get principal place of business definition, and then you get, once you start putting it all together, we have 5 or 6 regulations that talk about principal place of business and additional location. And if we were being totally topically rational about dealing with this, we would take this piece off the table and we'd say, we'll bring in the other pieces too that are on the same topic, and let's make it all consistent and right all at once. But we don't have topically arranged rules at this point. So, we've already undertaken one rulemaking in which the additional location concept has been moved forward to the point that we're almost to notice the new proposed rule for formal rulemaking. Not that there's much change to that aspect, but the concept is that we've already started down this road rather than trying to do this topical, bring everything together all at once thing. And as Chris pointed out in a recent discussion that we were having internally, we've got a couple rules here that have like this huge laundry list of like 15 different topical things. And they're all under one title, and they all have little sub-paragraphs. And the minute we start opening one of these rules, currently, we may be obligated to complete the opening. In theory, a group like this group could recommend to the board that they only look at piece A and B in this rulemaking, with the understanding that we're going to come back to D and E later in a separate rulemaking. In theory, we could try that. And I think that would be okay under the governor's order and under the current policy of the department. Other agencies in the department open rules for small pieces on a regular, many times a year even, basis. So just for tiny fragments. So, I'm kind of getting a little bit expansive here, but the problem is we do have a gummy mess, and we're touching on it, and we think there could need to be statutory change. And Tim's point is extremely important to realize that even in the history of things, it's different than it is in practice now.
So Tim, you and I are on the same page on this, exactly. So the question would be would we have to do statutory change before we could do regulatory change? But here's the issue for a dealership too. If you think about this, whether or not it's a big dealership or a smaller dealership that has 2 or 3 multiple locations, let's go back to license number 1, all on the same campus. 4 or 5 totally separate dealerships, all under one number. Let's say that the general manager and the sales manager go off the reservation in the BMW store, and tons of consumer harm, to the point where maybe the board needs to consider summary suspension. The whole license goes down.
Right, and that's an excellent point, and I knew where you were going with that, because we'd share that same concern.
Yeah.
And tell the dealer, you're really better off in having these licensed separately.
Right.
And now there's one out there I'd like to just shut down altogether. They can do it with one license, but that's another story. But all of them should be, I mean, from there, take ourselves out of the association advocacy role, the regulatory role, put yourself in the owner-operator functional role, and I'd want to have separate licenses and separate bonds on each of those stores, so that if you did have that run the risk of a compliance issue, that it's not shuttering everything you've got. And so, I mean, I think that's the argument on that's the argument on our side to convince anybody that thinks it ought to be under one.
So
That's the fundamental, do we really want additional location license?
Right.
And again, I think because the statute have opened the door on that.
No, I mean, I think we do want additional license.
Right.
And it's better, that's a better model than one license for multiple locations.
So why don't we do this? Why don't we look at to see if it's so ingrained in statute that we can't get to it by regulation, and then we'll just see if there's any traction for looking at some kind of statutory change.
In other words, just to make sure we're on the same page, and since Michael's getting charged with doing the drafting of the rule, so we just need to see if we can go far enough that we rein in that multiple locations under one license scheme, if you can call it that. You don't have an answer right here, do you?
No, not right now.
I don't hear him responding to it.
Not right now.
So,
I mean, I'm just looking at the first two sentences of 4, and I don't even know that they even mean anything to us anymore, do they? I mean, I guess it goes to the signage requirement. If it's immediately adjacent, you don't have to have a separate sign. Chris is shaking her head, so I think I got that part right. But that's the only purpose of the first two sentences in 4. Because as we know, you can have additional locations that are not adjacent.
At the risk of betraying my actual opinion, I will betray my actual opinion, which is, this is a topic. We should be dealing probably with everything concerning principal place of business and additional locations in one rulemaking event, and really putting it all together, looking at all the applicable statutes, looking at the current rule set that touches on it, and if necessary, extracting from all of the above to get to a rational totality. And, you know, we are dangerously close to creating more conflict between statutes and rules and rules and rules. Dangerously close. Let me have it now.
Oh,
Yeah, everyone's being very quiet over here. So I don't know if I can, you know, I mean, that's what I believe.
Yeah, the other statute to consider in regulations are statutory provision 12.6.117, and then also regulations under that pertaining to that specific statute, 12.6.117.1 and then 12.6.117.2.
And then we have to look at 110 for the fees and all that. I mean, there's so
right.
many statutory things that all, this has got tentacles that touch many different places, and I think we need to format a well thought out plan.
I agree.
So we don't miss any
That makes
pieces.
sense.
So what does that mean? I mean, what does everybody think we're going to do with 4 then? Do we leave 4 alone for now? Or do we strike 4 totally? Is 4 covered in other statutes and other regulations that we get there?
Or do we, as Leland suggested, say we're not going to tackle 4 during this, but in the next set of rules that we're going to look at, we're going to address all of these things, and we're also going to suck 4 up into that to make sure that they're all traveling nicely together. Oh, no.
Well, and the problem,
Settle that.
well, the problem with that is the next rulemaking events are probably in May of next year. They probably just are.
Well, for us, from the division's perspective, I think we all agreed that 4 wasn't really broken for us. I mean, we weren't having problems, immediate issues. So I guess my question would be, is the industry having immediate issues with 4, or can it wait till May? You know, I guess that would be the simpler way to look at it. I'm not putting you on the spot. You have to say right
Just
this
initially,
second.
we're not sure we need 4.
Right, I mean, again, I don't think Ford does anything dramatic that isn't in some other statutory provision. And I also support looking at the whole picture as Leland and Chris have proposed on additional principal and additional locations to try to shore up the whole regulatory scheme rather than piecemealing it. I think that makes a lot of sense.
So why don't we do this? CAD will tackle 1 and 2, and you might as well tackle 3, because you just want to add 1 line in there.
Right.
Let's table the discussion on 4 to see if it's even needed, if it's other places. So we may eliminate 4 altogether, or we may leave it alone. So why don't you guys look at 4 and see if it's a duplication of something in another place, and we'll look at 4 and see if we think it's duplicated in some other place that it's covered, and maybe we don't even need 4.
Makes sense. So the 17th at 6 a.m.
I won't
That's
be
a
here.
board meeting.
I'm out.
So 5.
Yeah, right, 5 a.m.
Let me see if I can get back on here. I
I saw Leland propose that date. Was it the 19th?
It's a
17th at 1:30 is the date.
Yeah, that's what the boss told me to say. I wouldn't ever propose anything.
Yeah, that is the thing I said.
So here's the deal. October the 17th at 1:30, we're going to take up everything again, and we will have, well, we're gonna go through everything again, other than the ones that we agreed that we had no change. Anything that we're gonna change, we will take that up again, and we will have drafts for that. But what we need is, we need to look at a reasonable day before the 17th where we could send out the things that we're going to tweak. And Mike and Matthew and Tim, you could send out this rule where you're going to tweak it, a reasonable time. So if we take it up on the afternoon of the 17th, I mean, is it reasonable to ask you guys to have something back to us by the 12th? Is that too early, or is that reasonable?
We can do that.
And we'll ask Mr. Seaman to do the same with his piece.
And then that way we could compile that on the morning of the 13th. It would go out in a separate email, but the board packet was going to be sent to the board on the 11th. But we could package this up on the 13th, and we could do a blast email to everybody so everyone would have this and have a few days to look at it before we meet on the 17th, the afternoon of the 17th. Does that work? Anything else before the committee that we need to talk about? Come to my agenda. Any public comments? All right, with that, let's adjourn. It's